ఇక బాబ్రీ మసీద్ సహా పలు అంశాలపై సుప్రీంకోర్టు ప్రధాన న్యాయమూర్తి జస్టిస్ చంద్రచూడ్ మాట్లాడుతున్నారు. ఇప్పుడు లైవ్ చూద్దాం.
The result of the economic complexities of our times. Many of the new laws that Parliament has enacted are regulatory laws, like the Insolvency and Bankruptcy Code. This gives rise to a lot of complexity of litigation, and that also reflects in the volume of the paper books which we have to deal with. Today, a paper book of say 20,000 pages is not unique, it's normal. That's the new normal that judges have to deal with. 30,000 pages. When we dealt with the Ayodhya case, for instance, 30,000 plus was the size of the paper book, the documents. When we dealt with Article 370 recently, we crossed that as well. Now, how do we equip judges to ensure that they don't lose sight of important parts of the paper book? So we have put into place a standard operating procedure for the filing of written submissions, for filing of joint compilations by lawyers, all this to ensure that the whole process of presentation of cases is streamlined, that there should not be an element of ambush in the course of legal arguments. Everything should be transparent. So my idea about incorporating technology as part of the judicial process is to make this truly a citizen-centric judiciary, a judiciary which is responsive to the needs of our citizens. So the object of incorporating technology is not to set apart the court from the citizens. It is to enhance transparency, bring out greater participation of citizens in the work of the courts, and to ensure ultimately that we are responsive to the needs of our citizens. Well, to give you the figures, we disposed of 52,191 cases from 1st of January to 15th of December 2023, and this exceeded our registered filing, which was 49,191, which showcases in a certain way effective case management. We did that at different levels. First and foremost, we did that in terms of streamlined case processing. In the time which is taken between the point when a case is actually lodged in the registry to the point of time at which the case comes up for actual hearing before the court for the first time, that period has been reduced from 7 days or even more, it was sometimes much more than even 7 days, to 5 days or less. We have prioritized certain types of cases, for instance, cases involving bail, cases involving demolition, cases which are extremely urgent, so that those cases can be processed even within a day and can be listed before the court. We have also put into place a procedure by which there is swift handling of certain types of cases: bail, habeas corpus, eviction, anticipatory bail. These cases can be processed and are processed, generally speaking, even in one day. So we have really first and foremost focused on the time which is taken from filing to the listing of a case for hearing before the court. The second important step which we took was for having specialized benches for adjudication of cases. The age in which we live today, and this is not something which is unique to the law, it's across the board. It's an age of specialization. And I thought that it's important that we must have judges with domain expertise hearing certain types of cases which require domain knowledge and domain expertise. So we have, for instance, just to give you one example, 392 Insolvency and Bankruptcy Act cases were resolved in a single judgment. I've constituted 3-judge bench special benches with almost 166 sittings addressing crucial matters and references. The areas where we have had specialized benches are land acquisition. Now, land acquisition cases deal with citizens' rights. Somebody whose land is acquired is looking for the grant of compensation, and it's not a sole individual. A single notification would cover hundreds, if not thousands, of our citizens. So, listing land acquisition cases in the Supreme Court not only ensures that these cases are disposed of by the Supreme Court, but they have a fallout in the High Courts, because then those decisions give guidance to the high courts on what the court is deciding in relation to a particular notification or in relation to a particular issue. Apart from land acquisition cases, cases involving compensation, these are basically cases involving motor accidents where citizens across India are affected by motor accidents. Sometimes where a death takes place, their legal heirs are waiting for the grant of compensation by the insurance companies. So we had a specialized bench for compensation cases. We've had a specialized bench for direct tax cases. We have had specialized benches for indirect tax cases, particularly in the context of the GST. We also have specialized benches for insolvency and bankruptcy, the commercial cases that we have today. So setting up domain expert benches where judges who have specialized knowledge in that branch would work on those cases has been really one of the key factors in speeding up disposals. So, but apart from this, we have been focusing on, say, criminal cases. Criminal cases, as you know, are the largest single source of filings in the Supreme Court. So criminal cases are dealt with almost by all judges. But within criminal cases, we have judges dealing with cases in which they have expertise. For instance, there were death references which were pending before the Supreme Court. And death references have to be disposed of at the earliest because somebody in jail under the shadow of the award of the death penalty, you can imagine the psychological impact on that person. There's a societal interest involved as well. So I requested one of my very senior colleagues, Justice Bhushan Gavai, to take up the death references. Death references go to a combination of 3 judges, and that has resulted in the disposal of a large number of cases involving the award of the death penalty as well. So these are some of the steps which we have taken. Greater use of technology in the process, and this is going to be a mission which I'm sure will continue for the future.